Good afternoon. I'm Russ Feingold, and I'm president of the American Constitution Society, which, as you likely know, is a national network of lawyers, law students, scholars, and policymakers who believe that the law should be a force for protecting our democracy and improving people's lives. We're glad that you could join us on Constitution Day, a day on which we commemorate the signing of the American Constitution in 1787. To be candid, though, it is also a day when it feels like this Constitution is very much under attack in the United States. It's commonly remarked that our Constitution is unusually hard to change. Indeed, in the 233 years since its signing, there's only been 27 amendments, and 10 of them were right away, the Bill of Rights. The last was a limitation on increasing congressional pay, which was ratified almost 30 years ago in 1992, after having been introduced in 1789. And I got the chance to actually vote for the ratification in the Wisconsin legislature after it had been around for a couple hundred years. The 26th Amendment was ratified almost 50 years ago in 1971. So this is clearly not a very frequent occurrence. Today, we're going to explore why this is and what the consequences are, specifically with regard to Article 5 of the Constitution. Many scholars and experts have talked about other ways that the Constitution is informally changed, and that is a source of many interesting discussions. But we're talking today about the formal mechanism, Article 5. We, in part, will look at a case study that is currently a topic of debate, the revival of the Equal Rights Amendment, as well as efforts underway to call a constitutional convention, which would be the first time in the history of this nation that there has been such a convention since 1787. I happen to love this topic. I've taught it at law schools for the last 3 years, and I find that it is understudied, but it's very important, and the American people really need to understand it. A few housekeeping notes before we start. We will take questions from the audience toward the end of their discussion. If you'd like to ask a question, please type it into the Q&A box on the bottom of your screen anytime during the program. Also, California CLE credit is available for this call. If you want that, please email us at info@acslaw.org to receive your certificate and write, quote, Article 5 event, unquote, in the subject line. If you need CLE in another state, you should see if it provides for reciprocity from California. Now we have a terrific group of speakers to engage with today. First, we're going to hear from one person who's going to set the stage, and then we will have a discussion by 3 panelists. And the first person we'll hear from is Kamala Lopez. Recently we had a wonderful program on the occasion of the 100th anniversary of the women's right to vote, 19th Amendment. And we had one of the most important constitutional law scholars in the country who's an expert on change in the Constitution with regard to women's rights, and that's Reva Siegel of Yale Law School. At the end, she was asked to sort of summarize what she wanted to say in 1 minute. And she made a powerful statement about the people who helped change constitutions. She said about teaching it that morning. She said, "This morning I taught the Marbury case, and from beginning to end, only men. And too often when I teach constitutional law, only men. And one of the wonderful features of the story is that it features a wonderful array of diverse constitution makers. I think it's really important on the theme of making constitutional law and making constitutional meaning, that we enrich the stories that we tell about where our law comes from and how our country was made. Tell stories that matter. It matters to know that those who made our law are richer in their backgrounds and experience and biographies and communities of belonging than the ones you're getting in constitutional law. Yes, you need to get the judges appointed," she said. "It's true. But mobilized people will make meaning if they can tell their stories that matter about who we are." That's who Kamala Lopez is. She is an actress, filmmaker, activist, and president of Heroica Films. She launched the movement and documentary film Equal Means Equal to educate the American people about the importance of equal rights under federal law for women and complete the ratification of the Equal Rights Amendment to the United States Constitution. Equal Means Equal was released in the summer of 2016, and it went on to win the Best U.S. Documentary at Michael Moore's TCF Festival and was a New York Times Critics' Pick. The film began to be used by activists across the country in community screenings, house parties, and online to reinvigorate the fight to complete ERA ratification. Equal means equal and Kamala are plaintiffs in a lawsuit filed in Massachusetts federal court seeking the National Archivist's certification of the ERA as the 28th Amendment. You'll hear about that in another lawsuit relating to this later on. But now I'd like to ask Kamala. Unfortunately, we can only do it for a brief period of time. She has such a great story to tell. It really sets the scene if we're going to talk about what Article 5 is all about in the modern context. Kamala?
Thank you so much. I am so honored to be here, and I'm grateful to Senator Feingold and his long-abiding interest and support for the Equal Rights Amendment, which would provide all Americans with equality under the law regardless of sex. When the ghost of Alice Paul appeared to me at the Smithsonian in 2009 and demanded why I hadn't done anything to ensure that American women had equal rights under the Constitution, my answer was, because women already have equal rights, Alice. Where have you been? Unfortunately, though, I was wrong and Alice was right. The 19th Amendment was the only right that women achieved in our Constitution, and that was literally a century ago in 1920. But hey, I'm not the only one in the dark. 96% of Americans believe that men and women are equal. Being disabused of this misinformation took several months and hurtled me through the various stages of grief, including disbelief, denial, blinding, seething rage, and ultimately determination to change the situation. I set out on a methodical fact-finding mission that led to hundreds of hours of research and interviews, the production of the aforementioned documentary, and culminated in creating the vehicle for the political advocacy and activism that executed the three-state strategy. Today, after 11 years of full immersion in the ERA, here are the facts. The US government has deliberately and illegally withheld basic equality, a foundational human and civil right, from a majority of its population by failing to include them in the Constitution and withholding from them the equal protection of our laws. The consequences of this exclusion are multiple, brutal, and correlate directly to the substantive negative outcomes that women face as a class. Over the past century, American women have, in good faith, followed the rules set forth for us by the US government as laid out in Article 5, which is the only place in the Constitution where the amendatory process is discussed. Article 5 gives Congress and the states the power to together add an amendment to the Constitution. Congress first proposes the language of the amendment, then if 3/4 of the states, which is 38, approve or ratify the amendment, the date the last state ratifies it, it automatically becomes an amendment to the Constitution. On January 27th of this year, after 5 solid years of re-educating, reactivating, and mobilizing women and our allies around the ERA, American women delivered the requisite 3/4 of the states when Nevada, Illinois, and then Virginia ratified. The law says that upon ratification, the U.S. archivist shall then publish the amendment to the Constitution. But he didn't do that. Instead, Trump's DOJ's Office of Legal Counsel wrote a legal opinion telling the archivist that he could not publish the ERA because Congress had put a 7-year deadline for the states to ratify. Equal Means Equal immediately sued in Massachusetts federal court, arguing that the deadline was only in the preamble to the amendment, not in the language of the amendment itself. The attorneys general of Virginia, Illinois, and Nevada also filed suit in Washington, D.C. with the same argument, that since the deadline was not in the language of the amendment, it cannot stop the states from ratifying it, because that would be a constitutional violation of states' rights, as set out in the 10th Amendment. This week, The U.S. Supreme Court docketed our case, Equal Means Equal versus David Ferrario. It is the only lawsuit representing women, both as individuals and as a class. And it is urgent that our voice remains in this conversation and does not get shut out. No matter how sexy the constitutional questions may be, the ERA is about protecting American women, and that must be the priority and focus of our efforts. This cannot become a conversation between the U.S. government and officials of the various states, all men, I may add, about the fate of women that excludes women themselves. As both ERA cases have the same legal arguments, they will likely be joined, and we must be willing to join forces and work together. We must also ensure that the U.S. Supreme Court does not refuse to take up our case and evade the existential question of whether women are now equal under the law. I believe that in 2020, the state has no choice but to grant women equality under law. With over 47% participation in the American workforce and 87% of the purchasing power, women will not tolerate being told to go back to 1923 and start over because a few old white guys thought 7 years was just about enough time for you to get your equality thing in order, little missy. This is not a tenable position for our government to take in these unique and challenging times. I contend that the courts must not skirt the issue or evade the spirit of the law in order to deny us its substance. If they do, then American women must question the validity of the entire system itself and our obligation to obey it and be compliant to it. If there are any organizations or attorneys out there who would like to submit or sign on to an amicus brief in our case to the Supreme Court, the deadline is October 13th, and we would very much welcome your support. And with that, I thank you so much, and I appreciate this opportunity.
Well, that was just a perfect way to start. Very, very powerful, and it's about a living, breathing attempt to amend the Constitution, not something that happened 100 or 200 years ago. So it's the perfect scene setter for us, and thank you. We are now lucky enough to go to an extremely good panel to discuss the implications of Article 5 in both its respects. We will have Wilfred Codrington, who is an assistant professor of law at Brooklyn Law School, Professor Aziz Hook of the Frank and Bernice J. Greenberg Professor of Law at the University of Chicago Law School, and Michelle Kellen, the Deputy Solicitor General of Virginia, who's a key player in the other lawsuit that Kamala was referring to. Let me begin, if I may, with Wilfred. He, as I said, is Assistant Professor of Law at Brooklyn Law School and a Fellow at the Brennan Center for Justice. He is a constitutional law scholar with a focus on constitutional reform, election law, and voting rights. And he's the co-author of the forthcoming book, The People's Constitution, 200 Years, 27 Amendments, and the Promise of a More Perfect Union, which examines the history of constitutional amendments and the tension between the overall progressive arc of constitutional change and the conservative grip on the broader conversation about the Constitution. He served as a law clerk for the late Judge Deborah Betts in the Southern District of New York and as a staffer for U.S. Congresswoman Eleanor Holmes Norton. Wilfred, could you start us off by going through the key legal elements of Article 5, how it actually works, how it's supposed to function, and any relevant history so that the people watching have a clear context on something that a lot of people are not very familiar with. Thank you so much.
Sure. Thank you, Senator Feingold and Ms. Lopez and the rest of the panel. So it's Article 5 of the Constitution is its amending provision. It sets out two ways to amend the document. The first one is very clear. 2/3 of each House of Congress adopts a resolution proposing an amendment, and then the states, 3/4 of them, either state legislators or specially convened conventions assembled in the states, they vote to ratify that proposal. So when you get supermajorities in Congress And in the states on board, you get a freshly minted addition to the Constitution. And in fact, as you noted, this is the way that we got each of our 27 amendments. Then there's the alternate route. The alternate route allows states to petition Congress. And if you get 2/3 of the state legislators to do so, then Congress is compelled to call a convention for proposing amendments. Any proposals emerging from this constitutional convention would similarly become a part of the Constitution if ratified by 3/4 of the states. Now, I use the word alternate very deliberately because not once in our country have we gotten an amendment through this route. Yeah, it's not for lack of trying. So for one, the Anti-Federalists in New York and Virginia, right after the Constitutional Convention, began pushing for a second Constitutional Convention when the ink of our Constitution was not even dry. And this was in an effort to overhaul the new Constitution. That effort quickly fizzled, but then there were closer calls throughout history that just kind of brought us closer to a Constitutional Convention. So in the early 1900s, during the Progressive Era, state legislators got behind a Constitution Convention call for the direct election of U.S. senators. So unlike you, Senator Feingold, before then, your counterparts were elected by state legislators, not the people, right? And the House got behind these measures, and for decades they were pushing for the direct election of senators, but the Senate was blocking them. The Senate finally got behind the 17th Amendment, which when ratified in 1913, gave us the right to elect our senators directly. Also, during the 1960s, in response to the reapportionment revolution, so that's the series of Warren Court era cases that established the one person, one vote doctrine. I went through it with my election law class this week. But in response to that, Senator Everett Dirksen from Illinois, he sort of spearheaded a constitutional campaign. And that got very close as well. It fizzled in 1969 when he died. And then the most recent call is one that some say is well and alive today. And that started in the 1970s and into the 1980s. And that one calls for a balanced budget convention to the Constitution. Each of these efforts that I noted came within 2 states of forcing a constitutional convention or Congress to call one. And in fact, the one for the direct elections of senators may have actually surpassed the threshold. So that's in contention.
Well, thank you. That, by the way, there's no way I would have ever been elected by a legislator.
I didn't think so.
Anyway, thank you. That was a great way to start this. And now we'll go to a very distinguished professor, Aziz Huq, who, as I said, the University of Chicago Law School. His scholarship focuses on how institutional design influences individual rights and liberties. He is the author with Tom Ginsburg of How to Save a Constitutional Democracy, which draws on other countries' experiences with, quote, democratic backsliding to show how constitutional rules can both hinder and hasten the decline of democratic institutions. Professor Aziz clerked for Judge Robert Sack of the U.S. Court of Appeals for the Second Circuit, and then for Justice Ruth Bader Ginsburg of the United States Supreme Court. And he's a member of our ACS Board of Directors and also of our Board of Academic Advisors. Aziz, you can really help us with understanding the context of our amending system vis-a-vis other amending systems in the world and the significance of it. You know, it's often said that ours is the hardest one to amend in the world, and I think that it's very interesting and important for people to think about the fact that, as I mentioned before, only 17 amendments in the history of this country since the Bill of Rights. So maybe you can give us the comparative context. Thanks so much.
Sure. Thank you very much for having me on this panel, Russ. Let me say something first about the difficulty of amending a constitution. It turns out to be quite a challenge to work out how difficult a constitution is to amend. There are 2 ways we might think about this question. One is we might look at how many obstacles a constitution puts in the face of amendment. Alternatively, we might look at how often amendment happens. The problem is that these 2 measures don't correlate to one another. Think about, for example, the United States, where, as Russ just mentioned, we've had a number of periods of intense activity of constitutional amendment, the first in 1791, the second in the wake of the Civil War, and the third in the Progressive era between 1909 and 1919. In these periods, constitutional amendment activity has been intense, but between them, constitutional amendment activity has been sparse, yet the text of the Constitution hasn't changed. Why would that be? Similarly, think or consider a cross-national comparison. The Constitution of Japan was modeled on the US Constitution. Its amendment procedures are similar to the US Constitution's, but use lower voting thresholds. Yet the Japanese Constitution has never been amended. So technically, it's the most inflexible constitution in the world. So how do political scientists think about this problem? What political scientists have done is to look at how frequently constitutions are amended and to use that experience to assign difficulty weights to different elements of the procedures used for amending constitution. So for example, you might have a particular weight that is assigned based upon historical experience to legislative ratification requirements, a different weight assigned to the executive playing a role. Once those weights are calculated, one goes back and adds up the weights assigned to each different constitution depending upon the barriers that it imposes. In this way, we get a measure that combines experience with a look or a weighing of the actual text. There are two important studies that have been conducted using this methodology. In both of these studies, the first conducted in 1994, the second in 2010, the United States is either ranked as the most inflexible constitution in the world or the second most inflexible constitution in the world. So that's, I think, where our constitution ranks internationally. Very briefly, let me address the other part of Russ's question, which concerns the idea that other countries impose constraints upon amendment in both textual and judge-imposed ways. So we all know that constitutions in their text can impose constraints upon how amendments get enacted. Our own constitution has a set of rules that Wilfred described. It also limits substantively the scope of amendments with respect to first, slavery, and second, equal franchise in the Senate, or equal franchise for states in the Senate. Other countries' constitutions take the same approach. For example, Germany's constitution constrains amendments to be consistent with its commitment to basic human dignity, right? Reflecting the post-war circumstances in which the German basic law was enacted. In other countries where you don't have that substantive constraint upon amendment, courts have generated a doctrine called the unconstitutional amendment doctrine that limits the scope of potential constitutional amendments to those that are consistent in some way with what the court perceives as the basic structure of the Constitution. The innovator here was the Indian Supreme Court, which developed this basic structure doctrine in a case called Kesavananda Bhartia, and then applied it even though the Indian National Congress rejected any limit on the power to amend the Constitution through a constitutional amendment. And the basic structure doctrine that was developed by the Indian Supreme Court has migrated around the world to jurisdictions as far-flung as Pakistan, Colombia, and Honduras to be used in very different ways to impose constraints upon constitutional amendment authority.
Thank you. In fact, just to add to one of our most interesting conversations in our seminars is this question of, is it possible to imagine an unconstitutional constitutional amendment being processed through Article 5? and whether the United States Supreme Court would ever take notice of that. I'd add one other thing to this, and that is that in addition to Aziz is pointing out the relative difficulty of our Constitution, other countries also permit, of course, sometimes constitutional conventions. I think there have been attempts in France and Australia, so even though we've never actually had one here, other countries have had at least attempts to revise their constitution in that way. But at the moment, we only have one sort of live constitutional amendment possibility, and that's the one we've already heard about today. And we'll go to our third panelist to talk about the current status of the ERA. Michelle Callan is Deputy Solicitor General of Virginia. She is counsel for the state in its lawsuit seeking to compel the National Archivist to certify the ERA as the 28th Amendment to the Constitution. Before joining the Office of the Attorney General, Michelle was in private practice, most recently in the Washington, D.C. office of Paul Weiss. She clerked for Judge Jane Stranch on the U.S. Court of Appeals for the Sixth Circuit and holds a bachelor's degree from Stanford University and a JD from Vanderbilt Law School. Michelle, could you talk a little bit about the issues in your litigation? We've already heard that 38 states have in theory ratified it, but some states have ratified it in the past and said they don't want to be considered to have ratified it anymore. And then there is this very big question of whether or not a time limitation can apply. Help us understand the possibilities of the ERA being certified as a part of the Constitution in this context. Thanks, Michelle.
Sure. So our case raises three substantive kind of key points about Article 5 and how the Constitution is amended. One of which is raised by the Department of Justice, and two of which are raised by 5 states that intervened in our litigation. So those include the deadline that Kamala introduced. There's also an argument about contemporaneity in Article 5. And then third, there's an argument about rescissions. So I'll take those in turn. The first one about the deadline, that is an issue, and that's often the one that's highlighted as a key question about the Equal Rights Amendment. The Equal Rights Amendment itself departed from prior practice in the 20th century where deadlines were placed in the text of an amendment itself. And then when the amendment was proposed to the states ratified the entirety of the amendment, including the deadline. Unlike those other amendments, the deadline affiliated with the Equal Rights Amendment was outside of the text that Congress proposed to the states. So in our case, the Department of Justice argues that this deadline, the 7 years associated with the Equal Rights Amendment, is fatal to it, and because the relevant deadline expired, so did the Equal Rights Amendment. Article 5, however, sets forth only 2 roles for Congress in the constitutional amendment process. First, Congress can propose an amendment, and then second, it can choose from the 2 modes designated in Article 5, and that's state legislatures or conventions. There is nothing in Article 5 that gives Congress the power to set forth other restrictions on the states external to the language that they propose to the states. And the reason why the deadline being inside of the amendment itself versus outside the deadline is important from an Article 5 context is when the deadline is inside of the amendment that the states, the states legislatures adopt, they are adopting the amendment itself. So in the event of a deadline that expired, and the question of whether an expired deadline can be fatal to a constitutional amendment has never been decided by courts, and that's something that's new. And so when a deadline is inside the text of the amendment itself, by virtue of states ratifying it, it becomes part of the Constitution, but by virtue of that deadline in the amendment itself, it's a non-operative part of the Constitution, akin to, for example, the amendment that's been the 18th Amendment, right? That by virtue of the 20th Amendment is itself inoperative. So because the amendment, the deadline here is outside the role that Congress has under Article 5, our argument is that the deadline is not fatal to the Equal Rights Amendment and does not stop states from ratifying and has not invalidated our state's ratifications. The second piece that's raised by this case is the question of contemporaneity. And so the 5 states that intervened in this case have argued that even if you set aside the deadline, too long has passed in order for the Equal Rights Amendment to be properly ratified under Article 5. We've argued that the 27th Amendment has essentially superseded that argument because 203 years passed from the time that the 27th Amendment was proposed to the time that the final state ratified it. So that's the contemporaneity argument. And then the third argument in our case is the question of rescissions. So there are 5 states that have purported to rescind ratification of the Equal Rights Amendment. It's a little bit more complicated than just that because the question of whether or not a state has even rescinded, that's not just a given. So for example, Kentucky's rescission was vetoed by Kentucky's governor. So whether or not these 5 states have actually rescinded is itself not just a question that we just accept. But even accepting that, no one has ever recognized rescissions. And in fact, the Office of Legal Counsel under prior administrations has been clear that states cannot rescind amendments, and nor is there any process by which a state can take away its ratification papers once they've been submitted. And I think historical practice really highlights this, both in connection with the 14th Amendment and in connection with the 19th Amendment. There were states that attempted to rescind their ratifications, and that was never recognized. So those are the 3 main legal arguments that have arisen in our case.
Well, that's just an excellent progression to go to a more general discussion. As I said, the ERA, and we've had some good detail on that, is the only sort of live wire right now. But that could change very quickly. And I welcome all of you, but particularly our 2 professors, to comment on the possibility that there would be a constitutional convention. This could become a very live thing quickly. Many people believe, particularly conservatives, that they're only 1 state away, 34 states, from having enough calls for a constitutional convention at the state level. My state, Wisconsin, where I am right now, became one of the most recent ones. And if that happens, this constitutional convention, in theory, will occur for the first time in American history. And the question then is, would it just be about the balanced budget amendment? Would it be about term limits? Would it be open-ended? Some critics claim that the movement for a convention is a threat to our democracy. Are they right? Who's behind the call for a constitutional convention? And would it be possible to limit the subject matter of a constitutional convention? I remember teaching my students that Alexander Hamilton was quoted as believing that it should be a singular item that should be considered whenever you consider constitutional topic. But it's not at all clear that could be done, could be delimited in this way, or what the rules would be for a constitutional convention. So there's loads of interesting things, and I would welcome you to respond and alert people to this possibility. Go ahead, Wilford.
Sure. Yeah. So there's a lot of questions in there, so I'll try to pick them apart a little, piece by piece. So yes, this never tried approach has it doesn't offer certainty, right? There's just a lot of questions that Article 5 raises with regard to the convention method, because the text of Article 5 is really scant. There's very little there. So you raised some of the questions. How similar must the text or the form of the Article 5 petitions be? How long do they last before they expire? I alluded to that one when I raised the balanced budget convention, because some of these haven't been passed since the 1970s or 80s, and they've just kind of been lingering out there. What are the rules for the convention quorum and voting, and how are people, how are delegates chosen? Those sorts of things are just uncertain, and frankly, they're not new. James Madison himself at the convention, he posed these questions rhetorically, and he was just saying the vagueness of this alternate route was reason enough to exclude it from the Constitution itself. So we are in the same position that they were in back then in the 1787 with regard to knowing. And so the other part you raised is the so-called idea of the runaway convention, right? And the concern here resonates most with scholars. and probably lawmakers and anyone else ever looking at this issue. And that relates to the scope of the convention, basically asking whether the convention agenda and the proposals that the delegates put out there can be limited to a particular topic, and specifically the topics listed in the Article 5 applications that prompted the call for the convention in the first place. So, you know, the answer is truly we don't know. It is risky. Legal scholars and jurists and others have examined this for more than half of the century, and they just have not come up with an answer. So that, I believe, should be deeply disconcerting. Frankly, I'm at a loss because I believe that the reasons that led for the campaign call, as articulated in these Article 5 applications, should confine the convention. It should. And similarly, if you think about the Article 5 conventions as commissions, right? Official documents that delegate authority to delegates, you would think that the commissions would explain the limits of delegates' authority at the convention. So that would limit the Constitutional Convention. But you can also think on the other end, when Congress is proposing amendments, when they're all together, they're not limited in the scope, right? And while I'm not sure that comparison is apt, I think more problematically, and this is just the realist in me, I just don't trust whoever's going to be deciding these questions is going to be deciding them in an impassioned and principled manner. I just can't believe that. But what we do know is that the closest analog that we have to a constitutional convention is the convention in Philadelphia. And we know from history there that those delegates were given a very limited mandate in their commissions, and it was for the sole and express purpose of revising the Articles of Confederation. And we know that they exceeded that mandate and they scrapped the Articles entirely. So the runaway convention thing is the thing that troubles most scholars, and it really kind of means it's a crapshoot.
Well, thank you, Wilfred. At that convention 200 years ago, the original proposal was that it would only be a constitutional convention, no congressional role. And that was rejected in what you said about Madison. But let's go to Aziz and ask him, you know, how serious of a concern is this? If it's a real possibility, should people be worried about what might happen? This view is generally associated with progressives, and conservatives are generally associated with the idea of maybe wanting a convention, although it's not 100%. I've run into people like Professor Lessig and Professor Levinson, who sort of say, well, maybe progressives would do well at a constitutional convention. But there are many, including myself on occasion, who have some squeamishness about this. So Aziz, could you comment on it?
Sure. I think a way of thinking about the likely path of a convention would focus upon what the source and nature of the constraints upon that body would be. In US law, you can generally break down, US constitutional law, you can generally break down the sources of law into, on the one hand, ideas and materials that date from the founding, and on the other hand, practices or precedent that have emerged after the founding. Case law, the official practice of Congress, or the official practice of a branch. For the reasons that Wilfred said, we don't have much by way of material from the founding era that decisively resolves either the scope question or the procedure questions that you, Russ, raised. Moreover, we don't have from the post-founding era precedent or practice of the kind that we have that shapes doctrine and constitutional understandings in other domains. In the absence of either an original understanding or a historical practice or series of precedent, what tends to fill the gap in our constitutional world is norms. Norms that emerge out of our political culture and out of our institutions. And one of the lessons of the last 4 years has been that under conditions of acute polarization, norms break down, norms fracture, because people cease to see themselves as engaged in repeat play. They cease to see themselves as part of an ongoing enterprise of democratic cooperation. And they play maximally their hand for today without regard to what happens in the future. If we think about a constitutional convention in that context, in a context in which there are no constraints from the original constitutional understanding or from post-ratification practice, and if we situate a world, a convention unconstrained by law in a context of deep, effective polarization and elite partisan polarization, in which the rewards for complying with whatever norms of democratic political life we have are increasingly threadbare, I would say asymmetrical on one side of the political spectrum, I think that we I would come to see a convention as posing a unique risk of conflict and destabilization to our democratic political order. I think the countervailing argument, although it's an argument that at the end of the day I don't accept, but I understand where it's coming from. I think the countervailing argument is that our democratic political order is already in such peril because, in part, of increasing inequality in the economic domain, in part because of the breakdown in the public sphere, and in part because of the inherent dysfunctions of our constitutional design, in particular the biased representation of the country in our Senate and in our electoral college. I think the contrary view says, look, these dysfunctions cumulatively are so bad that, Huck, your comfort that the status quo is acceptable and rolling the dice on chaos is a bad option is just false, right? The status quo is really bad. So I think one's view about the Constitutional Convention really, at the end of the day, turns on how bad you think things are now.
And I think that's a tremendous point, because I would suggest that the outcome of the election may well help decide whether or not there is a real possibility of a constitutional convention. If it goes a certain way, it is possible that people, particularly on the right, may see this as the only route to restore some of the things they want to do, and it may galvanize the effort to finish the job in the state legislatures, which sort of relates to my last question for the panel before we go to the broader Q&A from the people watching. And that is, you know, a lot of progressive groups whom I've often agreed with are looking at the possibility of proposing constitutional amendments, usually in the context of going through the congressional route, but sometimes through a convention. And the question is, if you want to overturn Citizens United on campaign finance reform, if you want to abolish the Electoral College, if you think we ought to be like almost every other country in the world and have a constitutional right to a clean environment or a right to education, is this a good way to go about it? Heather Gerken, Dean of the Yale Law School, has referred to whether something is worth the candle. You know, is it worth the effort to go that route? And I would just ask you to respond vis-a-vis the interests of many progressives on issues they care about, whether the constitutional amendment route is something that they should consider or whether they should look more at other means.
I'm happy. Or
no, go ahead.
No.
Go ahead.
So I understand those points. But I think Aziz just highlighted some of the really troublesome baked in factors that make any sort of change that a lot of progressives are calling for really, really difficult, right? You start with the Electoral College. The fact that someone can actually lose the majority of the country by 3 million votes, that's the majority will there, and be elected because a very slim majority in a few states, you know, that doesn't sit well with a lot of people. The ERA litigation is all about actually including women in the Constitution for the second time, but in a broader context than merely the right to vote, right? The Citizens United, we're in the 10th anniversary of Citizens United now. And that has destroyed, I mean, going back to Buckley, but it has destroyed the idea of common sense campaign finance regulations. And you know what? Because of the baked-in factors like the Senate, those are hard to come by. That said, I think there's value, one, in pushing for this, because history shows when you actually get a mass movement and you actually can break through some of these issues, the polarization, you start getting people on the streets demanding sorts of justice, as we're starting to see now, you can actually accomplish some tremendous things. Nobody thought the amendments that happened during the civil rights era were going to happen. I mean, we had a stalwart Southern bloc blocking everything that was good and right about expanding the right to vote to include Black people and other people. Like, that looked impossible then. It looked impossible to bring about a 13th, 14th, and 15th Amendment. And yeah, there were power politics going on there, but we had an entire war about that, right? It looked impossible to actually get the Bill of Rights in the Constitution in the first instance. But, you know, when you actually come together and think about these things, there is a possibility. So it might seem slim, but I want to also just talk about the other sort of factor there, which is the externality. Even if you don't succeed in getting these amendments, there is power in actually building that movement, the movement to actually push for these things, to try to get those sort of problems out of the way in other ways, sub-constitutional ways, legislative ways, through the courts, pressing our political actors. And I think that the arguments against pushing for these sort of devalue the actual power of these social movements to actually accomplish some things, even if it's not everything we want.
Great answer. Aziz, if you could quickly give some comments, and then if Michelle say a word or two or make a comment or two about this, and then we will go to Kara and get some questions from the audience.
Yeah, I disagree with Wilfred on this point. Social movements are clearly extremely important for the reasons that he said, but the question on the table is, what should social movements push for? And on this point, my view is that you can hear, by the way, the voices of the 5-year-old future demanding the right to constitutional change in the form of juice. This is what happens when you have kids at home. The payoff from constitutional change, as opposed to change through the enactment of statutes and regulations and transformation of regulatory structures that do not require or do not trigger the kind or do not require navigating the obstacle course that's Article 5 is far greater. So to go back to Heather Gerken's is the game worth a candle metaphor, my view is that the game of constructing a new healthcare statute, a new environmental regulatory framework, call it the Green New Deal or something else, the payoffs for that are far greater given the political obstacle costs than the payoffs from a constitutional.
Well, that was a great exchange. Michelle, can you conclude this part of our program with your thoughts on this?
Sure. So I think, you know, one of the things that's important whenever someone embarks on any sort of endeavor is to both recognize the ideal of why you're embarking on it, but then also what does that entail? What are the benefits of costs, and how do we go about doing it? And I think everyone here pointed out there are a lot of challenges to amending the Constitution today, and perhaps more so than in the past. The fact that we have been unable to amend the Constitution in the last 49 years, and the only amendment within that time period is one that was relatively uncontroversial about congressional pay, that might show something about where we are as a country. And there are all kinds of factors that people can think about as to why it has become so difficult to amend the Constitution. But the Equal Rights Amendment is kind of a good example of that. We are the only industrialized country that does not explicitly recognize sex equality in our Constitution. And sex equality is something that's very uncontroversial for the overwhelming majority of Americans. So in light of that, why is the ERA controversial? And I think that highlights some structural problems that exist in our society. I don't purport to be able to pinpoint many, if not any of them, but some that come to mind, something like gerrymandering, for example, or other political structures that make it difficult to do the things that our founders intended us to be able to do. And I know this is really corny, but maybe this is a good place to end. Our founders did not purport to be perfect. In fact, they wanted the Constitution to enable us to form a more perfect union. And we've since availed ourselves of Article 5 to improve our Constitution. If we think about the way our Constitution has changed since the founding of our nation, these are extremely important changes that reflect who we are as a society. And so the fact that it is difficult now for us to amend our Constitution in a way that's consistent with the values of the overwhelming majority of Americans, that might shed light into some of the broader problems that exist in our country as a whole. And so I don't have an opinion as to how advocates can best go about achieving their goals, but it's important to be realistic about the structural problems that exist in our country, and utilizing whatever measure is realistic to reach one's goals.
Terrific conversation, and we have about 10 minutes left for questions from the audience, and we'll go to Kara.
All right, thank you, Russ, and thank you, panelists. So I'm going to try to consolidate some of them so that you can organize yourselves. There are a few on the Constitutional Convention, a set of issues, so I'm going to give them one by one. Could a Constitutional Convention result in a reversal of many of the rights we enjoy? Does the need for 38 states to ratify limit the possibility of a runaway convention? And has anyone tried a mock Constitutional Convention to see how this might all work? I'll leave it there.
Wilfred?
Sure, I'm happy to talk about this. So I think, could it result in rescinding some of the rights that we enjoy now? Potentially, right? That's the unanswered question. We don't know what the limits of what a convention is going to consider and what's going to get out of the convention. The other question was, have people tried a mock convention? Actually, there are some groups that are pushing these constitutional conventions that are doing these mock conventions. They're just kind of a little bit of a circus. They're dressing up as characters from the Revolutionary era and beyond and putting on these hats and saying this. And they're just raising like these little quibbles with each other, nothing like the types of problems that would actually be raised at the Constitution. And then the last question is, would the 38 state ratification threshold change things, or at least protect us? Potentially, that's right. But what we also know is that when constitutional amendments are proposed, they tend to be ratified. We have 27 amendments in history that have made it. 33 have been proposed. So 6 have been proposed and not amended. I don't know if I like those odds. You know, it just seems to be, at least if we look at our history, that when there is a substantial enough majority to push out a proposal, states kind of get behind it and they ratify it. So that's, you know, whether that threshold's enough beats me, but history doesn't seem to be on its side.
And just a quick point on that is that there's an option in the Constitution where the ratification is done by the legislatures or by conventions in the states. And that can have a major substantive difference in terms of whether something gets through. Aziz or Michelle, do you have a comment on that?
I don't have much to add to what Wilfred said.
Okay. Kara?
Right.
Do you have
So let me give you a few that relate more directly to the ERA situation. Is there a difference between states rescinding their ratification of an amendment and states rescinding applications for a constitutional convention? So this is actually a combination of our issues.
Right. That's a really interesting one.
Yeah, I'm happy to jump in, preliminarily on this. I think it's more of a question, is there an academic difference? Because a court has never ruled on it, right? I think there is a reason to look at the two differently. And so with regard to legislatures ratifying, or when Congress proposes an amendment to the states and then it goes to the states for ratification, once a state ratifies, that's kind of a ratification in toto and forever. And that's the way that we've understood ratifications. And so if you want to think about it from a contract perspective, for example, the offer was extended and then it was accepted by the individual states, and then you have the contract. In contrast to the convention, it's the offer, it's the states that are essentially at that point, until all of the states agree to the convention, you haven't reached agreement. And so they're a little bit different in that sense. And so I don't know that that's the argument the Supreme Court would ultimately adopt if that were presented to the court, but there is an argument as to why the two should be considered different.
I think we have time for one more question, because in my experience, vast experience on Zoom, they'll cut you right off at 60 minutes. So go ahead.
All right, well, I'm going to cheat then and put a few of them together. How about that? If the amendment process is automatic, why does the archivist need to certify them? And if the Constitution has been amended with the addition of the ERA, can we all sue on it? And then my final question, or the group's final question, is might the ERA litigation lead to a proposed amendment to the Article 5 amendment process?
That's a lot to do your best.
I'm happy to jump in on the first two. So our theory of the case is that the moment we ratified, the ERA became the 28th Amendment to the Constitution because of the language of Article 5 that the amendment shall be part of the Constitution upon ratification by the requisite number of states. Technically, whether or not one can sue today is not set in the sense that the ERA itself has a provision in it saying that it does not take effect for 2 years. So that 2-year clock started upon Virginia's ratification. So there might be a question as to whether an individual has standing to sue or whether that suit is ripe before those 2 years have passed.
And one thing that I want to jump in on here is that we sent out letters to all of the states attorneys general, asking them whether they were going ahead and taking the ERA as law and doing the work that they needed to do to start examining whether these laws were discriminatory on the basis of sex, and none of them are doing it. So there is like direct injury to the process of the ERA because the archivist is listening to somebody that's telling him to do something and so it is having an effect, even though he's just sort of the librarian guy that writes it in and it's no big deal. Nobody else is acting like it's already the law, so that is a problem.
Now, I'm going to have to finish this very quick.
2 quick points. The first, I think it's important to recognize that whether an individual can enforce a federal constitutional interest depends upon whether there's a federal statute that grants that person the right to come into court and ask for damages or an injunction. So the question of who can enforce is completely separate from what rights are in the Constitution.
All right. Well, I have to thank the speakers who were just superb. If audience members still haven't had enough constitutional conversation, we'd like to invite you to join us next Thursday, September 24th, for our annual Supreme Court preview, when we'll discuss the cases and issues before the court this coming term. There's more information on our website. We are extremely grateful for your help on this important topic, and thank you everybody for joining us.